Hello everyone. I'm here today with Michael Kobler and we are talking about the proportionality in IP litigation. While proportionality is a bit hard to pronounce, it's not that hard to understand. It's about the question, what do we do if an infringement does not cover the whole product but only a part of the product? Take as an example the light of a car, not the whole car. And this has become a really hot topic in patent litigation because there is also new legal developments and a draft bill that's currently being discussed. So, Micha, before we speak about this draft bill, what is the current situation? Maybe you can give us an overview.
Yes, sure. In patent law, one has to distinguish between the various claims resulting from patent infringement. So on the one hand, we have, for example, claims for recall and destruction, which are excluded if they lead to disproportionate results. This is stipulated in the law, in that case, Section 140A of the German Patent Act. And on the other hand, we have the claim for injunctive relief, which is almost automatically granted, and the chances to successfully raise a disproportionality defense are not very promising currently. So there is a recent case by the Federal Court of Justice in the Wärmetauscher case, in which the court said that you can, in principle, raise the defense of proportionality, but there's high hurdles, and in the case at hand, the application of this defense was denied. So how is this in trademark and in design law?
Well, actually it's quite similar. My impression is only that it's a more established and elaborated system. It's not that hot, that new as in patents. We have been discussing this for years. But as you said, we need to distinguish between recall and destruction or damages, where you have these considerations, and the injunctive relief, where it's more complicated, especially if you take a case, as I said before, the light of a car. Do we prevent the whole car from being distributed and manufactured, or only that light? If you cannot isolate them, you cannot take the light off a car very easily. So in most cases, typically you have the whole car being subject to a court decision. And in some cases, it has been discussed to grant grace periods, meaning that you get more time to actually comply with the judgment on the infringement, so you have more time to make changes and implement changes that are necessary. Is that something discussed in the patent bill as well?
Yes, indeed. The draft bill suggests that the claim for injunctive relief is excluded insofar as its fulfillment would lead to disproportionate disadvantages for the infringer or for third parties, considering the specific circumstances of the case. And the small word insofar, in German soweit, indicates that the courts have a certain discretion with regard to legal consequences. And the draft bill, or the reasoning of the draft bill, expressly mentions the possibility to order a grace period, for example, to sell off infringing products or to change the production so that the infringing functionality is deleted from the product. So what arguments do you have to make and which facts do you have to present in trademark law and design law to make that case?
Well, infringers need to show actual facts and circumstances why complying with the court order immediately is not possible. So the burden to show that is very high. You need to present facts and arguments showing that the change cannot be made easily and that balancing all the interests, you need more time. For example, if you have to change your company name, the labels for products, etc., it may not simply be possible to make the changes now, right away. And then you can argue, okay, we need a grace period, we need more time to implement those changes.
Okay, interesting. And another question, which is expressly mentioned in the draft bill, can the owner of the protective right demand a compensation if the claim for injunctive relief is completely denied or partially limited, for example, by means of a grace period?
Well, there's very little case law on that confirming any sort of compensation. But I would say it will be extremely difficult to get such a compensation because we just said the claim for injunctive relief is limited insofar as it would be disproportionate. So you don't really have a culpable infringement, which means that you would probably not get a compensation. On the other hand, if there is this draft patent bill and if it's going to be like that, of course, even in trademarks and design cases, there will be considerations, okay, do we have to apply the same principles here on that topic? So when exactly can we expect to have that bill in place?
So that is a very good question. The draft bill is currently discussed, and a final vote by the German Parliament, the Bundestag, is expected for spring 2021. But of course, the wording may still change because there's an active and hot public debate, and public statements are being presented, for example, by the Association of German Car Manufacturers. And so it will be interesting to see when and in what form there will be a change to the German law on proportionality and injunctive relief.
Okay, so maybe when you see this, there will be changes in place already, and maybe not. Or we will see what changes there will be. So stay tuned, look in our website, our social media channels. We will keep you updated. Thank you very much.